Hi, this is Sheri Byrne-Haber. I'm really pleased to have been invited by Eric and the folks who organized this meeting today to give you a little bit of a global accessibility legal update. So I happen to have a perfect storm of a background to be in accessibility. I'm a wheelchair user with a deaf daughter. I started off with a degree in computer science. I became a lawyer and then I got an MBA. So I kind of have a 360-degree view of accessibility from all perspectives. I can see why it's important, but what it costs. I have to give the standard US legal disclaimer. Please don't rely on anything in this deck as legal advice. I'm not your lawyer. You need to get your own lawyer. So first of all, I'm going to talk about Canadian accessibility law. I'm Canadian originally, so this is something that really interests me. I'll touch for a second on the EU, but really focus on the UK law. You guys already know the EU law, but the UK stuff might be interesting to you. And then the law that I'm closest to, the US law, we'll look at California law and new litigation trends. So first of all, the Accessible Canada Act, which is also known as Bill C-81, was passed last summer. So who does it cover? It covers Parliament, the Government of Canada, the military, and what we call regulated entities, which is the federal regulated private sector. So that's largely transportation, broadcasting, the RCMP, banking, insurance, and telecom. There's an interesting clause in the Accessible Canada Act, which says that the development and revision of accessibility standards must be done with the objective of achieving the highest level of accessibility for persons with disabilities. Since this was passed last July after WCAG 2.1 came into effect, my interpretation of this is that the standards will have a phased-in approach using WCAG 2.1 at level AA as the standard. So the proposed timeline right now extends all the way to 2026. The details of the implementation have been somewhat delayed due to coronavirus. This is an accessibility law that encompasses much, much more than digital accessibility. It includes built environment, so physical accessibility, employment, which includes job opportunities, standard ICT, which would be like Section 508 in the United States, any procurement of goods and services, any delivery of goods and services, and transportation. So we've got several different things to look at with respect to the EU. First, we've got EN 301549, which regulates public sector bodies, and that's non-commercial bodies governed by public law, associations, state, regional, and local authorities. So the hard deadline kicks in for that September 23rd of this year. Everybody's probably aware of all that and is tired to death of hearing about it. The European Accessibility Act is still a little bit up in the air. The regulations that are in place require member states to adopt and publish their own implementation laws by June 28th of 2022, and 3 years later, by June 28th, 2025, applying those laws nationally. Now, the commissions could cite compliance with EN 301549 as equivalent to compliance for the EAA. Currently, 301549 only applies to websites and apps. So what that would do is it would take the EAA and effectively extend EN 301549 to products and services above and beyond websites and apps. A lot of people suspect that that's what's going to happen because it's the least amount of work that's compliant with the overarching regulation. But since we're so far away from June 28th of 2022, nothing has really happened yet with respect to the member states actually doing the adoption. So that's going to be the key, and we will need to follow that closely to see how each individual member state implements the EAA. And then finally, we've got renegade countries like Sweden. Sweden came out with a statement from the procurement agency saying that goods and services must be available to everybody regardless of their ability to function. That actually goes above and beyond both the EAA and EN 301549, and there's no reason why other countries couldn't do that as well. We're seeing a situation with COVID where people with disabilities are being hurt even more than people without disabilities. For example, in the US, we can't get groceries delivered because not all the grocery delivery apps are accessible. We can't, 41 out of 50 in the US of the unemployment websites are inaccessible, yet all of the unemployment offices are closed, so people can't go into the office to make their claims. This is really a serious problem, and I think countries in the EU and states in the United States making their local regulations stronger than the federal regulations is going to be important to digital accessibility law moving in a positive direction going forward. So with respect to Brexit, EN 301549 was implemented by a local law in the UK. That's true for all of the European Accessibility Acts. Each member state has to implement that as their own local law. What that did is that means there's a local law. It's not that the UK was relying on EN 301549, they implemented it themselves. Brexit does not automatically cancel the UK implemented law. It would have to be explicitly repealed. Chances of that happening, it requires the British Parliament getting their act together. I don't see it happening. Even if it did happen, we've got a couple of things that also exist in the UK that are independent of EN 301549. BS 8878, which has been the standard since I think sometime after 2010, exists as a fallback with a reliance on WCAG 2.0. And then there's an ISO standard that uses 2.1 as its basis is ISO-30071. So that is also a possibility. So we've got 4 cases in the US that are really important with respect to litigation. 4 of these cases, all 4 of these cases are against private entities. These are all stores. In the US, we call them public accommodations. So they do explicitly come under the Americans with Disabilities Act, and they all involve selling something. Domino's sells pizza. The Supreme Court declined to hear the case, and it left the Court of Appeals ruling in place, which mandated accessibility. Domino's is still fighting it, so you haven't heard the last of this one. The Hooters case, which is a restaurant chain, cited that you can be sued multiple times by different plaintiffs, even if you're in the middle of remediating. So you can be sued by one party, enter into a private settlement agreement, and while you're in that settlement agreement solving the issues, you can get sued by a different party. The only time this is not the case is when the first party was a class action lawsuit. In the US, some lawsuits are class action, which means they represent everybody who has been discriminated against in that way. Other cases are individual, so you have to look at those carefully to figure out what the implications are. But for the most part, I would say maybe 80% of the accessibility lawsuits in the US are individual, possibly higher. There have been a few class action lawsuits, which means if you've been sued by an individual, especially one of the people who've made a profession out of suing people, you can be sued by other individuals in the same situation. There is a third case called Winn-Dixie. Winn-Dixie is a large grocery chain in the US. Think of it kind of like our own Aldi. And the Southern District of Florida ruling mandated accessibility for Winn-Dixie. Why is that important? Florida is a really conservative court. So the feeling amongst lawyers is that if Florida is going to mandate accessibility, everybody's going to mandate accessibility. And finally, another interesting case was the GNC case. GNC is a vitamin company, and they have stores where they sell all GNC products. They also sell in various different pharmacies. So in that case, they tried to claim that their IT head was an accessibility expert. And all of the accessibility testimony got thrown out because the court decided that he wasn't an expert. He'd only taken a couple of accessibility webinars. He wasn't certified. He didn't have any training. So the core component of that particular case is whoever you claim is an accessibility expert, if you get sued in the US, they better damn well be an accessibility expert. So California law is basically the same as Swedish law in that California is always on the cutting edge of accessibility and disability related protections for its citizens. So there are three things that make California law really important. We're 10% of the United States in terms of population. Lots of people either do business from California or do business in California. So any state in the US can pass laws that are more protective than the federal laws. The federal laws are a floor. So first of all, we have something called the Unruh Act in California, and it's a $4,000 per ADA violation minimum fine. The reason why that's important is because the ADA itself, as a federal law, only allows you to get injunctive relief, meaning you can force the company to do something. There's no monetary damages involved. This is why 42% of the cases in the United States are filed in California, because there's a financial incentive for the plaintiffs here. They get $4,000 per violation. Secondly, we've got the California Consumer Privacy Act, or the CCPA, which mandates that all privacy pages have to be compliant with 2.1 AA. This is the first law in the United States that mandates 2.1. And it took effect January 1st, but they gave everybody 6 months to get caught up. And so July 1st is when the Attorney General in the state of California may start going after people who are not complying with these 2.1 requirements for privacy pages. There's a third piece of legislation in California that I'm actually working on called AB, stands for Assembly Bill 2123. It has not been passed. It is currently on hold, but was active as of a week ago. So this is not a hold, meaning it's in some corner where we're waiting for it to die. The only reason why it's on hold is because the legislature is focusing on coronavirus bills right now. What AB 2123 proposes is that there are statutory damages if a website fails to provide equally effective communication or facilitate full and equal enjoyment of goods and services. So what does that mean? It kind of tries to clarify things to prevent lawsuits using 2.1 as a standard. Now, it says internet website, and I'm making air quotes around the term website. It actually includes mobile apps in the definition of the website. What it's trying to do is it's trying to eliminate the people who are serial plaintiffs who are filing hundreds of lawsuits against hundreds of different companies by saying that the people actually have to prove that they've been harmed, that they couldn't enjoy the goods and services, but it's also making the standard higher, but easily measurable by saying that WCAG 2.1 AA is the standard. In terms of trends in the United States litigation, the first trend that we started seeing about 15 months ago was employees suing employers for discrimination based on lack of accessibility. The first case to come out was Bartleson versus Miami-Dade County. It was $1 million verdict in favor of the plaintiff, as many of these cases are, where the employer, the Miami-Dade County, was required to provide the woman assistance and JAWS scripts and what have you until everything became 2.1, or it might have been 2.0 compliant, until everything became accessible. She was a blind psychologist in a school district. Second trend we're seeing is whistleblower lawsuits. So there was a lawsuit against a contractor. Conduit is owned by Xerox Corporation, and Conduit contracted with the state of California to produce a Parks and Recreation Department website. And they said it was going to be accessible, but they didn't test it very well. And when the state of California refused to enforce that contract clause, Mr. Bashan, who is legally blind, sued based on a whistleblower complaint, saying that Conduit effectively committed fraud against the state of California by saying that they were going to make the website compliant and not following through. So that case has been allowed to proceed. It's overcome the first hurdle. It will be interesting to see what the outcome is. Another trend that we've seen is Braille gift cards. There were about 200 lawsuits filed at the end of 2019 about Braille cards, about gift cards, apologies, that don't support Braille. The courts are getting really fed up with cookie cutter lawsuits. And in particular, the courts wrote in Dominguez versus Banana Republic, which was the first case to get a written ruling, that the plaintiffs' attorneys were doing a terrible job, that they are not specifically alleging harm, and as a result, that they were not going to interpret the law to include Braille gift cards.